Now recording.
Oh,
Just all right. Should be good. Are we on time? Everybody have
10
seats?
o'clock on the bell.
All right, you guys ready to rock and roll here? Just going? Well, hey, this is a fantastic turnout. So thank you for coming. I am Nick Spio. I am with Stivers, an operating company of Talent Launch. This is our space here. So welcome. Please make yourself at home while you are here. We are going to welcome Seth Briskin today for today's topic. And I think it's quite timely. And, you know, we were kicking this idea around a month and a half ago of having some sort of event for our clients and for their guests as well. So some of our clients are here today and some of you are not, but everyone is welcome. And we're kicking around topics and Seth threw this around. But we said, how about November 6th? And he's like, well, that's probably a bad time to have this. So we kicked it, we punted it down a week, and but nonetheless, great topic. And in talking with all of you this morning, I know a lot of you are super interested in this as well. And yes, we got the presentation a couple days ago, and I didn't take a peek because I wanted it to be brand new to me and sit back and listen and see what we could learn, see what we could look forward to in the coming year or years, and go from there. So great topic. Seth is here. He's with Myers Roman, a local law firm, and some of you know Seth. Some of you are big fans of Seth already, and we heard there's some groupies, Seth's groupies out there. So you guys are welcome as well. So, but I'm going to kick it over to Seth and take some here. And again, welcome and enjoy the time. Thanks all.
Thank you. Cheers for. All right. Good morning, everybody.
Morning.
Good morning. That was lame. We're going to do it one more time and loud because we've got St. Louis and we've got Kansas City also listening in.
Yes,
so Cleveland represents. Good morning, everybody.
Good morning.
And good morning to everyone in virtual land. Welcome. Thank you for hosting again. My name's Seth. I'm your friendly neighborhood labor and employment lawyer with Myers Roman. Been doing it all my life. And when we were talking about this subject, I thought about this topic. And I don't know about you in your workplace, but politics has been all a buzz. Everyone's worried about the future. And my secretary, my assistant, no different. And so she's in charge of my slides. And so you'll see a couple of slides and I'll show them where she took some artistic license and you'll sort of get her political bent when you see some of the slides. But a lot of uncertainty, a lot of unrest. And the topic today that we're going to talk about is trying to tap into my psychic powers. And I do have some. I just picked Emma over here, and I figured out exactly why she was named Emma. It's friends, by the way. And so I do have some psychic gifts. And so I thought, can I look into the future and think what is going to happen going forward? And can I educate and can we plan a little bit better what I think is coming? So before we get started, I know a whole lot of people in this room, and I don't know a lot of people in virtual land, but let's just get a show of hands, see what we're talking about, and I can sort of get this talk going to your direction. How many of you are in HR or HR adjacent? Okay, good crowd. How many people own businesses or run businesses? Good number there too. Anybody have unions? Sweet. I got a piece just for you. Any others you want to yell at me and maybe I'll tailor a comment or two your direction? Anybody else that doesn't fit those categories? Good. Okay. Let's talk some turkey. So before I start my talk, I generally like to begin these things with a lawyer joke. Sure. It's not because I believe I'm terribly funny, although everyone tells me I am, so it must be true. But if you get nothing else from today, at least you get a lawyer joke, and as my wife is fond to say, even a bad lawyer joke is a good lawyer joke. She lives with one, so that's a constant reminder of lawyers. So here, little known fact, by the way, if you Google this, I thought for sure I was going to find a topical joke for today and find a lawyer goes to a psychic or a psychic goes to a lawyer. I researched hard, no joke. Couldn't find a joke. So I'm going to separate out the jokes. I'm going to tell a lawyer joke and then I'll tell a psychic joke, maybe two, but a psychic joke for sure. Okay, first lawyer joke. And this is as close as you can get to a psychic lawyer joke as you get. Lawyer's walking down this not a lawyer, man is walking down this beach, beautiful sandy beach, white sand, beautiful blue day, and walking across, and all of a sudden trips over something, looks down, and it's a lamp. And the lamp is covered in sand. He wipes it off. Sure enough, poof, a genie shows up. Bim scala bim, thank you, my master, for freeing me from this terrible, terrible lamp that I've been trapped in for centuries. Because of your kindness, I'm going to grant you 3 wishes. But I warn you, part of my curse, 3 wishes I grant you, anything I grant you, lawyers are going to get 2 times more. So really think about this when you ask for your wishes. And the guy says, this is fantastic. I don't care. Lawyers, who cares? I want to go. Let's go. I got wishes. And the genie says, okay, what's your first wish? He goes, I want $100 million. And the genie says, $100 million? You realize every lawyer is going to get $200 million? The guy's like, I don't care. I'm not greedy. I don't need $1 billion. $100 million will set up me, set up my whole family. I don't have to worry about money the rest of my life. I want $100 million. The genie says, it's in your bank account. What's your second wish? He says, well, my second wish, I'm a huge car nut. Huge car nut. I don't want this year's Lamborghini. I want the Lamborghini 10 years from now. And I want a convertible, and I want a cherry red. And the genie says, every lawyer's going to get that unbelievable car too. Are you sure? The guy says, I don't care. I can only drive 1 car at a time. That's what I want. The genie says, it's in your driveway as we speak. And then the genie says, and with your third wish, what would you like? And the guy thinks about it for a second. He goes, I want you to just beat me half to death. You guys got that joke. That's it's a good sign. You could also go with, by the way, I want you to remove one of my kidneys, but that also is okay. So that's a lawyer joke. Psychic joke. Did you hear about the really, really short fortune teller who was on the run from the law? She was a small, medium, at large. Kind of dad joke. I'm gonna stop there. You guys are ready to go. All right, that's good. So I think I'll get this going. So I don't know about you. Those of you in HR probably get this too. But every cocktail party, every dinner, breakfast that I go to, I get the question: what's coming next? What is the future for employment law? And when you're in a cycle with any given president, regardless of administration, you can sort of guesstimate. When you're here right now where we are today, and that's why this is a first-time talk for me, you don't really know. However, I think I can make a couple of very easy general predictions about what's coming our way. So here's the general ones, and then we're going to get into the weeds specifically, okay? So what does it hold? State law is going to be and continue to be far, far more important than federal law. If you haven't noticed, Congress doesn't churn out a whole lot of laws. They're at loggerheads all the time. So changing federal law, very, very difficult. Changing state law, not nearly as difficult. And when you have states like Ohio that are very, very one-sided, changing those laws much easier, and they affect your lives day to day, because oftentimes the federal law kicks to the state law. So state law more important. State law will change more in the coming years than federal will. No questions asked. Okay. Next one. Again, you HR people and you business owners have to know this, but we are now in dealing with the EEOC here in Ohio, the OCRC, the Ohio Civil Rights Commission, the court system here, and it's not different. If you go to Philadelphia, as I do frequently, to Chicago, all around the country, the court systems, they're grinding to a halt. They're moving very, very slow. On the EEOC and OCRC side, oftentimes I forget I even have a live case with these organizations. They are taking so long to get back to you with an answer. And as I'll talk about in a little bit, the game these days, you don't even get to a decision with these agencies now, but the process has really ground down to a halt, and that is going to continue, unfortunately. Okay, before I get to some predictions, I want to just start with what I consider to be the bedrock of employment law. This is the law of the land, and when I say the law of the land, it is the law of 49 of the 50 states in the US. There is only one wacky state out there that does not follow employment at will. And for you groupies out there who have seen me talk before, do not answer the question. But there are 49 states that follow at-will employment, and I'll explain what that is in a second. You should all know what it is, but I'll explain it in detail. What is the one wacky state that does not follow at-will employment in the United States? And it's not California, Oregon, Washington, New York, or any of the New England states.
Utah,
Utah, good guess, but not it.
West Virginia.
Also good guess, not it.
Colorado,
Who's the smart person? Hey, Montana. Yes, Montana has moose law, but they do not follow at-will. Yes, that is the one wacky state. Even Montana follows at-will for a period of time, and then it moves into a quasi just cause standard. But yeah, Montana is the only one. Otherwise, at-will employment is the law of the land. And when I tell you what at-will is, if you don't know, it's a very simple concept, and yet people get flummoxed about it all the time. Very smart people. So what does at-will employment mean? I'm going to just run it real quick. It's a two-sided coin. So employers can terminate employees for any reason under the sun, and employees can leave for any reason under the sun. And that balancing act is what keeps at-will employment the law of the land. So employees, forget about 2-week notice. That's a myth. They don't have to wait 2 weeks. They can just walk into your office and do the old Johnny Paycheck song. Take this job and shove it. Okay? And they can leave you at the worst possible moment. I represent some big accounting firms, mid-sized accounting firms, and these accountants get burned out. And on April 13th, there's a walkout. And 10 accountants walk out the door. And the managing partner is screaming, "Oh my God, Seth, oh my God, Seth, 10 of my best accountants just walked out the door. You've got to go file something and get them back." You know what? Slavery got outlawed a long time ago. You burn them out. At-will employment, they can leave you at the worst possible time. You didn't take care of your employees, they left you. Tough. Okay? On the flip side of that coin, employment at will, employers can terminate employees for any reason under the sun, with or without notice, with or without a good reason. It could be a stupid reason. It can be a factually incorrect reason. Any reason, as long as it's not an illegal reason. And we'll talk about the illegal reasons shortly, without legal liability. Now, that simple concept still confounds people to this day, and I get the call all the time. "Oh my God, Seth, oh my God, Seth, I've got the worst employee in the world. Terrible performance, terrible attendance, a morale black hole, the worst." I said, "Okay, at-will employment, fire them, fire them." "Oh, you don't understand. She's a 65-year-old Jamaican with a club foot and diabetes and a bunch of other things." And my great legal advice is, so what? So what? At-will employment. Now, is that employee a riskier fire because of some of the things we're going to be talking about? Yes. So if you learn nothing else from this, there's three platinum rules of employment law. Get out your pens. This is gold and platinum. Number 1, document. Number 2, document. Number 3, document. And that third document has got a little asterisk, and it goes down to the bottom and says, make sure you give Seth or your employment lawyer really, really good documents. Because a bad document can sink your whole case. One bad document can sink your whole case, and I've seen it a million times. So document, and keep good documents. Should you need them? No, you should be able to terminate at will. However, as we'll talk about in a second, no one else believes that on the government side or on the plaintiff's bar side. We'll talk about that. Okay. Even though at will makes a ton of sense, and it's a pretty simple concept, they can leave, you can fire, any reason under the sun. There are some exceptions to at-will employment, and I list the ones up here. Again, you get calls all the time. I've been wrongfully terminated. There's a hostile work environment. Those are big terms. That's not everything. Wrongful termination are these 4 things, and not a whole lot else. So first 2 I'll just take together: promissory estoppel, implied contract. That is when you make a promise, whether it's written or oral, that is so promissory in nature that the employee reasonably relies on the promise to their detriment, and there's damages as a result. So the classic example of that is a client of mine, big company, multiple plants in different states, some union, some not union, and they lost their head general manager of all the facilities, and they did a massive search. They did psychological tests. They met with the family. They flew them out 3-4 times. They finally found their guy who lived in California. They scribbled out a very nice offer letter that looked just like a contract, promised him the sun and the moon, great salary, great benefits, great bonus, company car, flying all over the place, all paid. You name it, it was in this letter. Okay? What does the guy do? He relies on that letter. He pulls his family together, tells them about the great job here in beautiful Northeast Ohio. And unlike a lot of people, he moved from sunny California to beautiful Northeast Ohio. That was the plan. Sold his house in the worst real estate market ever, took a bath on the house, pulled his kids out of school, packed up the family truckster and started heading east. About halfway there, my client's biggest customer folded and left them with massive AR, not doing any more business. The company lost 60% or so of their business overnight. So, at will employment, right? You shouldn't have to hire that guy. He's on his way, but you shouldn't have to hire him. There's no job for him anymore, right? Well, promissory estoppel implied contract. That case became a case because that guy had real damages. He relied on a real promise to his detriment, and we ended up settling that case. Not a good case. When you hear about that, your natural reaction as a human being is to go, ugh, that really stunk for the general manager. That feeling, that's damages. That's a promissory estoppel case. So that's that. Public policy case, a funky little court end around at will employment that sort of started with the idea that a woman was suing a company for harassment and discrimination and was in court, put her hand on the Bible, swore to tell the truth, whole truth. The plaintiff's lawyer started asking her about the workplace, and she said, yeah, this is a towel snapping, misogynistic, chauvinistic, absolute den of thieves, the worst environment I've ever seen. I've seen groping, I've seen harassment, I've seen outright threatening, and it all starts with that guy right down there, the CEO of the company, and she points right at him. Okay? Now, if she had gone up to the CEO next to the water cooler and said, you know what, sir, your company stinks on ice, and you stink too. It's top down. You're the cause of all this nonsense. You're the worst boss I've ever had. Could that guy fire that gal? Of course, at will employment, right? But because she put her hand on the Bible, swore to tell the truth, the whole truth, nothing but the truth, and she finished her testimony, went back, case closed. 2 weeks later, CEO fires her. Okay?
Retaliation.
It's a retaliation case, and it's a public policy tort because we as a society want people to feel like they are protected when they put their hand on the Bible and swear to tell the truth and whole truth. So that is a public policy tort. When something makes you go, ooh, that shouldn't be right, retaliatory nature, things like that, that's a public policy tort. And then lastly, protected classification discrimination. That is the big one. That is Title VII. Here in Ohio, it's 4112, and that is race. That is disability. That is age. That is veteran status. That is national origin, you name it. All the protected classifications, gender identity, all protected. If you terminate somebody for those reasons, illegal. You can't just do it at will anymore. That's an illegal reason. Okay? However, this is going on in other states, and it's more recently the play here in Ohio, and that is Governor DeWine passed a law to bring us, Ohio, into step with other states. And so in the good old days, 5-6 years ago, plaintiffs could go running straight to court. Didn't have to file with the OCRC or the EEOC. Now they have to go to the OCRC and EEOC before filing any kind of discrimination or harassment charge. So as you'll see, the stats are proof that this is happening. But it also has created this game with employment lawyers here, both between the plaintiff's bar and the defense bar. And so, long story short, there's a very prominent plaintiff's attorney here in this town who shall go nameless. And I had lunch with him, and I said, you know, so-and-so, I've got to thank you. I've got 6 cases on my desk from your firm, and every lawyer in my department that I oversee, they've got all kinds of cases from you too. And I got to tell you, they're all garbage. They're garbage cases. My clients aren't terminating people for age or discriminatory reasons like that. They're garbage. And he said to me these words: you might not think these cases have merit, and they might not have merit, but they all have value. Think about that for a second, okay? Because that's the game now. They're filing cases. You go to the OCRC, the EEOC. We've got to defend them. You got to pay me or someone like me to defend them. That costs money. We're going to, look, I beat these things for a living. 99.9% of the time, we win these cases. If we get there. But the game now is you never get there. The plaintiff lawyer or the plaintiff pulls the case away from the EEOC or the OCRC. They get what's called a right to sue letter, and then they go to court. So you're defending it not once, but twice. Okay? The costs go up. So when my friend, the plaintiff lawyer, says cases have value, even if they have no merit, that's what he's talking about. A scary prospect, but that's what's happening to at-will employment. And it's under attack from all sides. And as we'll see, the government also plays a role in this too. So I like to teach by stats. These stats will tell you something. If they tell you nothing else, they should tell you this. There's never been a bigger premium on training your employees and your supervisors than right now. Okay? Because your employees, they need to be trained so they know that every little thing that goes bump in the night is not a harassment case or a discrimination case. And you need to train your supervisors so they don't step in it, because I'm going to teach you a little Latin. Respondeat superior. Supervisors stand in the place of the company. So whatever they say, whatever they do, whatever they grope, if it's the CEO of the company, the president of the company, or the company itself did it. Okay? So your supervisors need to be trained. And we do at my firm a ton of supervisory training. It should be mandatory. Looking forward to 2025, and I'll talk about the heroes at the end. That's going to be one of them. Okay? So just to measure and show you what the past administration and their EEOC has done, this should be no surprise to anybody. But in fiscal year 23, so we don't have the 24 data yet, the EEOC had 81,000 plus charges of discrimination. Okay? That's a lot of charges. And every year since COVID, it's gradually gone up. Okay? And that's not a surprise with the Biden administration, with these new laws coming into play where you have to file with the EEOC or the OCRC. So these stats are going up. Okay? Not surprising. Everyone thinks, as a result of the Me Too movement, that sex harassment is the biggest claim that the EEOC or the OCRC will get. Sex harassment, sex discrimination. It's rarely in the top three. Rarely in the top three. Every year, more or less, going in, going out since 2009, it's retaliation, which makes some sense because retaliation is honestly the easiest thing to prove, because an employee does something that's protected, and then 2 weeks later, a month later, 6 months later, a year later, they get terminated or demoted or something bad happens to them, and they say it's retaliatory to what they did before. It's just it's a time lawsuit more than anything. Okay? Doesn't even matter if it was truly discrimination under the law. So not surprising that retaliation keeps winning the race every single year too. But let's talk about the EEOC and that 81,000 charges. The EEOC, when they get a charge, it's going to go one of two ways. It's either they're going to do their investigation and they're going to get affidavits and do what they do, and we're going to defend. And then it comes to a decision point, if it gets that far. And the EEOC has to decide, is there probable cause that discrimination or harassment occurred, or no probable cause that discrimination or harassment occurred, okay? Now, you can throw out the numbers, and if you're groupies of mine and you know the stats, do not yell out. But what percentage of 81,000 cases to the EEOC do you think have probable cause? In other words, they're more probable than not than to be discriminatory or harassing in nature.
10 to 20%.
Pessimist, no?
75.
75%. Yes. Anybody else? Someone want to play the middle game?
32%.
Price is what? Price is right. 32%. The answer is, drum roll, 10%. 10%. 10% are found to have probable cause, and this goes every single year. 10%. If you were in the major leagues and you batted 100, how long would you last in the major leagues? Not very long. You couldn't even stay in the minor leagues batting 100, even as a catcher. I hate these catchers. That's a terrible batting average. Where on earth did the EEOC get up only finding 10% of these things? Well, it tells me a couple things. Number one, there's no training out there because employees are running to the EEOC and the OCRC. And by the way, I have the stat up there that shows also the OCRC's stats went up. They had almost 6,400 charges. And I guarantee you it's going to come in around 10% are going to be found to have probable cause. So 90% of these charges have no merit. Not enough merit even for the EEOC or the OCRC to find meritorious. So how is it that those percentages are so bad? It's lack of training, lack of understanding, supervisors not educating either. That is why those stats are so bad. Okay? Also, I would tell you the EEOC and the OCRC, they are funded by tax dollars. So they want to show big numbers year after year to justify their budgets. So they don't dissuade people from filing bad charges either. They take them in and then they process them and you're off to the races with a discrimination or harassment case.
I was going to say, are the employees using this as a scapegoat because their companies are not engaging with it?
Oftentimes that's the case. That's why towards the end, when I'm talking about some cures, I often say the greatest litmus test in the world is a severance agreement. If you don't take care of your employees on the back side, you very well may end up in front of the EEOC, OCRC, or a plaintiff lawyer. So we'll talk a little bit about that too. A good question. If you don't engage with your employees, and if they don't see it coming, they could think it's for a nefarious reason. Okay. Let's get to some psychic stuff. Okay. Now, if I had shown you the picture that my assistant put up there first time of Donald Trump, you would know exactly where her political favors lie. I nixed that and I went more presidential. So I say at the top here, I have mild psychic powers, but I'm not a full-on psychic, but I do know this. The best predictor of the future is the past. Okay. So we've seen it for 4 years before. So it shouldn't be a big surprise as to what's coming down the road. It's just a question of how fast it can happen. I'll explain a little bit about that too. But first term Trump, next term Biden and Harris, and now we're heading into second term 2025 of Trump. So this is certainly a very divisive topic. And when I'm going through what these changes that I see on the horizon are, I might sound critical. I'm trying to stay right up the middle here. As a good defense side lawyer will do his best to do. I'm socially kind of liberal, but defense sided. So take my comments with a grain of salt. I'm going to tell you if it's good, bad, and different, and what the changes that I think are going to be coming. So exempt versus non-exempt employees. When I say that an employee is exempt or non-exempt, everybody understand what I'm talking about? Yeah, I see a lot of heads nodding. You don't. Lots of big companies, Bank of America, they thought they knew all about exempt employees too, and they had tons of these quote unquote vice presidents running around in very nice business suits right out of college, holding onto clipboards and running around their banks and having people fill out this information to bring it in, and they filled it out and they helped the client do that, and then they passed it on to the office person, and that was their job. And they called them vice presidents, and they paid them $75,000 a year across the country. Plaintiff lawyer got a wind of this, and next thing you know, multi-million-dollar settlement, because those quote-unquote vice presidents were not exempt employees. You can dress them up in suits and nice business skirts if you want to. That doesn't mean they're exempt. Just because you pay them a salary doesn't mean they're exempt. You've got to dig one level down, and when we talk about some of the cures at the end, employment law audits, this is a big one, because there is no bigger issue for the DOL, certainly the Biden administration, than the misclassification of employees, whether it's exempt, non-exempt, or independent contractors. So this is a big one. A change of sorts just came across a month ago, 2 months ago. So there was a big ruling in Mayfield versus the U.S. Department of Labor that established that the Department of Labor does have the right as an agency to set what's called the white collar exemptions. Okay? White collar exemptions, you can go back in time again. Great predictor of the future. The Obama administration tried to raise the salary level of the white collar exemption to, I'm gonna get it slightly wrong, but it was around $47,666 or something like that. $47,000. That was years ago, and everyone was in an uproar. Nonprofits were in an uproar. Retail's in an uproar. Restaurants were in an uproar. I've got lots of restaurant clients that were freaking out because you've got. Keep it down up there, Laura.
I'm not expecting it in my chin, but whatever.
And they were flipping out because here in the sort of middle of the country, I don't consider Cleveland Midwest, but we're tending that way. Unlike the coast, where $47,000 doesn't sound like a lot of money, here there's lots of general managers and people who open up Rite Aids and nonprofit employees who make less than $47,000. And what would that have done? A lot of the nonprofit clients I represent and their executive directors who get paid less than that, they work 60 hours a week, 80 hours a week. It would have turned them into overtime eligible, and that would have jacked up the costs for these nonprofits. They would have been going after your wallets twice as hard, or had to keep the staff. That was frightening. It was frightening. So frightening that a group of lawyers in the Chamber of Commerce sued the Department of Labor and stopped that effort by the Obama administration. So it didn't raise. Okay? Cycle forward to the Trump administration. Trump actually increased it. Now, he didn't increase it to the levels that the Obama administration wanted, but it went to the 30s, 35,000, 36,000, somewhere in there. Okay? Now here we are again, the Biden administration DOL, they raised it again, back up into the 40s, and it got stopped. The law that the DOL actually passed said it's going to be in the 40s as of July, and then in January 1, which is coming, it's going up to 58,656. which again, here in Cleveland, and for those of you in St. Louis and Kansas City, that's an okay living. And lots of nonprofits, lots of restaurants, lots of retail. They've got tons of people that make that money and less, and they're going to be overtime eligible. If this law goes, if this DOL rule goes forward, once again, there is a lawsuit trying to stop it. And at least at last glance, when I was seeing what the arguments look like, they believe the cases in Texas, where all Democrat efforts of passing laws go to die, the great state of Texas, the cases down there, I would anticipate it's going to get stopped. If it gets stopped, then it falls back to the Trump administration and their DOL to either set a new level or don't set a new level. Based on how much Trump was sort of working towards the middle class and trying to make promises on the campaign trail, this might be another area you look back in time. He did raise it. He might raise it again, but he's not going to raise it into the 50s. You can almost guarantee that. That's a good prediction. Okay. This DOL rule is going to be a big hot button. So really pay attention, especially if you own businesses, because this is a game changer for some of your people. You want to engage in what I would loosely call a wage and hour audit. And I've got clients that I'm doing this with right now, trying to figure out on a spreadsheet, how many people do we have under the July level and the January level? And if we think it's going to flip, you're going to have to make some changes. This is a big one. And you may have to turn what otherwise would be salaried people into hourly people. You may have to put controls on their hours. You may have to hire more. Lots of things in flux with this one. So this prediction is a big one, and it's potentially a really big change that's coming. Okay. OSHA. I was talking to some people in back there, Steve in fact. Big part of my practice is right down the street that way. And that is where OSHA is located, here in Cleveland, at the end of Oak Tree Boulevard. And I am there all the time, representing my clients with the good people at OSHA. And by the way, they are lovely people at OSHA, friends with a bunch of them. And they know, and believe me, this Cleveland office, little known fact for those of you not from Cleveland, and I bet you this will be a surprise to lots of people in Cleveland. That Cleveland office is either the first or second busiest OSHA office, not in Ohio, in the country. In the country. So Howie Eberts and his gang, they are out there. They are citing, they are finding, they are doing their job. And they go to sleep and look at themselves in the mirror every single day with not a problem in the world. Why? They are out there to save lives. And they are out there to enforce the laws that are there. And I represent lots of Amish contractors. And believe me, they do not follow all of those laws all of the time. They follow God's law, not always OSHA laws, okay? That is, construction is a big, big area for OSHA, and OSHA is doing their job, and they're doing it well. Just had an OSHA investigation at a client of mine where they just wanted to do a quick in and out, just wanted to see how we had an ergonomic complaint. The company let them in, didn't call me. OSHA came in, they checked out the ergonomics. There were some things that could get fixed, but ergonomics, you can't cite, there's no violation under the law for ergonomics. They can give you some suggestions how to improve your ergonomics, but once the OSHA is in your facility, everything they see, they can cite. And this client took them on a full tour, gave them everything but a magnifying glass and a flashlight. And believe me, in a big foundry and manufacturing, they found some stuff. They found about $90,000 worth of stuff. Okay? Now, that's when I got the call. Oh my God, Seth, oh my God, Seth. I got $90,000 of citation. Well, that 90,000 turned into 20 or so, 30. Because I thought they miscited some things and we defended the case. Okay. So OSHA is out there, and OSHA during the Biden administration, very, very vigilant, and you have to know that. And OSHA changed the game a little bit in some very major ways, and I list them here. They expanded the right, even if your company doesn't have a union, they allow union representatives to get a call and come through on an inspection of your plant now. Okay. That's a game changer. That's very, very interesting how they're OSHA partnering with the NLRB and trying to increase unionization by doing that. Okay, increase penalties. The penalties go up and up and up every single year. If you get whacked for a willful or a repeat now, it's somewhere in the neighborhood of $136,000, $8,000, maybe more. It goes up every year. That's a painful one. And I list another one that I had to fight, instance by instance violations. And this one got hit to an Amish contractor of mine, 7 guys on the roof, all not wearing fall protection. And instead of hitting one of them and getting all of them for the same violation, they went bing, 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 bing. 7 times $300,000 because they got them for training and for fall protection. $2.1 million. That's a big number. And it got there real fast. Okay? Instance by instance. Yeah.
Does that flow to the owner personally, or is it stop at the end?
It's a corporate required pay, or you're in contempt, and I've had a couple of those in my lifetime too. If it's criminal in nature, willfuls can get criminal. So if it goes criminal and they can prove that the owner knew about it, they can go after it criminally. And if the company isn't created well with lawyers and corporate protections, in theory, you can pierce the veil and go after them. It's a very rare day when OSHA does that, but they've gone after some bad actors. Okay. They increased reporting requirements, electronic reporting. If you're in HR, OSHA jacked that up. So now you have to report if you're in certain industries electronically. That all came during the Biden administration. And they just proposed a new heat standard, which provides for rest periods due to heat. That's a big issue for OSHA. Okay. So all this expansion in OSHA has happened during the Biden administration. Everyone, this is a tough SVEP. Anyone know what SVEPs are? Severe Violator Program. If you get listed on the SVEP, the next time you get visited, it's guaranteed willful. Okay? So you don't want to be on the SVEP list either with violations. That's why not allowing OSHA to come in willy-nilly and take an inspection of your plant without counsel present, probably not the best idea going into 2025. However, we'll talk a little bit about what I think Trump is going to do. Interesting thing with the Biden administration, EEOC, and OSHA, even during the Obama administration, it was a rare day when you saw the EEOC and OSHA put out press releases for hitting companies for $100,000, $50,000, $150,000, $200,000. It was usually $500,000 and up in the Biden administration. Every time EEOC hit somebody for a settlement of $50,000, $100,000, like, look, that's real money. Don't get me wrong, but that's not earth-shaking money, not for the EEOC or OSHA, and not for me in terms of settling a case. So that is, again, part of the strategy of the Biden administration's agencies to get the word out, scare you into compliance, which is not a bad strategy, by the way, and announce when they hit some home runs or singles or doubles, sometimes bumps. Okay? That's going on right now. So predicted future, again, if you take a look at the picture, if you can see it, I asked my secretary to put up a picture of Johnny Carson and Karnak that tells you how old I am. Well, she didn't do that. She put a funny picture of Trump under the turban there. So the predicted Trump future is what I say here. He did it in his first term. He just froze hiring. He depleted the OSHA ranks. And you did not see the same level of enforcement and certainly not the same level of punishment if you appealed it up the chain that you see now. I've got cases right now that I could get rid of 50%, 40% in that range every day when I'm litigating it up to the Department of Labor, solicitors branch, and the region, which is Chicago for us here in Cleveland. I'm telling you, every day, twice on Sunday, I'd be able to settle cases for real reductions. I had one, the $2.1 million one. The government countered my initial offer of settlement with 2.0999999.99. It came down a penny. Federal mediator didn't think that was all that funny. And I said, that's not good faith negotiating. And he said, I agree with you, Seth. But they are telling you, you have to litigate this case. They want to put your guy out of business, which I never heard in the Obama administration, Clinton administration, no administration. That's what was coming down from the DOL. We've got other wage and hour cases. Couldn't settle them. They did not move. So this has been a very tough administration on the safety and health side and the DOL side. That is going to change. That is going to change. You can almost guarantee that Trump's going to go back to his playbook, and he's going to do what he did best on The Apprentice. He's going to fire a whole lot of people. He's going to fire the heads of these agencies, and he's going to put so much pressure on some people. And I've already heard about some people thinking about leaving government work, that they don't want to be put in the position of being on the chopping block. So that is coming. Trump has threatened, and then he pulled it back, but we'll see if he does it this time, to reenact Schedule F. Schedule F, which I think probably starts off a pretty bad swear word, and firing, is the effort to say to civil servants, you don't have civil servant protections anymore, you're an at-will employee. So we'll see if that comes to pass. Labor law and unions. Okay, I'm going to say this with all the emphasis I can. I used to work at the National Labor Relations Board as a young intern, idealistic as I was, that's all been ground out of me. And I worked at the board, and the board only did a couple things. The board was involved with unions, either in union elections, union unfair labor practices, unions, nothing but unions. Well, that started to change during the Obama administration, and it certainly changed during the Biden administration. Now the NLRB is getting into non-union businesses by filing charges against companies because of your handbook policies, because of your agreements, your severance agreements, your employment agreements. They're finding them illegal under Section 7 or other parts of the National Labor Relations Act. So even non-union employers are on the hook with the NLRB these days. And there has been no administration, bar none, that has been more pro-union than the Biden administration. He walked a picket line. I can't remember another president that's ever done that. He has systematically through the NLRB made it, I list them all here, he's made it hard for employers to enforce workplace misconduct rules. He has he's made it much harder to decertify a union, much easier to certify a union, quickie elections and things like that, very fast pace. He has tried through both the NLRB and the FTC to eliminate non-competition agreements. The general counsel of the NLRB came out in big words about non-compete agreements and doesn't like them, believes they violate Section 7. And recently, the general counsel of the NLRB came out against stay and pay provisions. Stay and pay provisions, we write them all the time. If you want to send one of your employees to college because they show promise, or a trade school or something like that, and you are willing to pay the tuition, all you ask in return is to stick around for 2 years. And if you don't stick around for 2 years, you owe some money back for us educating you for somebody else's benefit. Okay, write them all the time. NLRB said nope, illegal, violation of the National Labor Relations Act, and I can virtually guarantee you that is not going to hold up. Okay. They changed when I write severance agreements, separation agreements, employment agreements. I'm putting NLRB qualifier language in all of those agreements now because of the Biden administration. You can't put confidentiality bars on employees when they settle cases anymore. You have to say you still have the right under the National Labor Relations Act to discuss this terms and conditions of employment with fellow employees. So there's protective language that if you're not doing it, you should put it in all of your agreements. So we'll talk about that also. What is Trump going to do? He's going to, number one, he's going to install a more pro-business National Labor Relations Board. He's going to bring in members. There's one seat that isn't filled, so he's certainly going to fill that one. And he's going to rebalance the NLRB to a more business-friendly group. And if I was Jennifer Abruzzo, the general counsel of the NLRB, I would have my bags packed right now. She's gone. And by the way, it's not just Trump. Biden fired Trump's head of the NLRB the minute he got into office. So, you know, anytime someone asks me what's the future for employment law, it's that the pendulum is going to swing. It's going to swing. Employment law is the plank that almost every politician has to have a platform on. It's your job. It's your livelihood. You get your benefits from it. It's very important to American voters. And so when a new administration comes in, they are going to push policies and laws and regulations and rules that favor their side of the ticket. No questions asked. So this is coming. And it shouldn't be a surprise. And this is not an indoctrination of Trump. The Biden administration did it too. So did the Obama administration. So did all the administrations before them. Okay? That said, I found it fascinating that during the RNC, Trump had the president of the Teamsters up there on stage speaking, sort of in his favor. I mean, I've never seen this before. Never seen this before. And Trump did you can argue with me, but he did a masterful job of taking away what has been a stronghold for the Democratic Party, and that's the working class. It's absolutely unfathomable that union people are voting Republican. It's never happened. It's happening. So it should tell the Democrats they are somewhat losing their way, because I've never seen a Teamsters guy speak in the RNC. That was flabbergasting. So what is Trump going to do? I think he's going to have to repay some favors. He's going to want to do what he's done in the past, but I think he's got to temper them a bit to keep that base interested in future election. By the way, if you're not getting the tone of my voice from any of this, all these regulations, it's not easy to do business with them. And when you put on top of the federal laws, the state, I've got clients who are leaving Illinois because Illinois is becoming very, very coastal in its laws and policies and rules. And there's a business flight out of some of these states. It is, when I'm doing a client with multiple states, I hope and pray one of them is in California. Very difficult place to do business. Lovely place to visit, very difficult place to do business. And that is happening in various states. And that's why I said at the beginning, watch state law. State law is more important than fed. Okay, immigration. Just real quick on immigration. I put up some stats. The Biden administration only had 400 I-9 audits during the last year of the Biden administration. Trump had 12,000 in his. So what is going to happen going forward? I half joke and I say it. What do you think Trump is going to do with regard to administration? If you didn't somehow, if you managed to live in a cave and not see any of the commercials during the political season, I don't think you have to be a psychic to figure out what Trump is going to do on immigration. Okay? It's going to ratchet down. It's become very, very difficult. Okay, artificial intelligence. It's everywhere these days, and I do separate standalone talks just on AI and its impact on employment law. There's major impact on employment law. People are using AI to screen people, to do interviews. They're using it in conjunction with cameras in the plants to figure out that people aren't working at their jobs, and using it as a disciplinary measure. Unions don't like this, by the way. So this is a big, big issue. And the Biden administration, God bless them, they got out there and they came out with big time AI executive orders, and their concerns are understandable. They wanted to keep AI as safe as possible if employers are using it, and they didn't want bias to be injected. The old saying, garbage in, garbage out. Well, if you're using bad algorithms that are biased in some way or discriminate against parties in a certain way, what do you think the AI is going to tell you on the way out? If you did a search around you, I want to hire somebody around my business. I want them nearby so they come here to work. And your business is in a lily white area out in the sticks somewhere, and that's your search criteria, and you use AI to do it, you are discriminating almost certainly with who you are interviewing and who you are hiring. Okay? So that kind of stuff. The NLRB I mentioned before, they don't like the use of AI when it comes to privacy issues and getting an employee's business during the workday. So that's out there too. What's the future for Trump? Well, his good buddy Elon Musk knows a lot about AI, and certainly I think Musk and other tech professionals that Trump is buddies with, they're going to have a lot of influence in the use of AI. Trump has made comments in the past about not restricting AI quite as much as certainly as the Biden administration, so we'll just have to see. But rest assured, AI is going to continue to be an issue statewide, no questions asked, case law. There's already lawsuits being filed about discrimination in the use of AI.
I was going to ask you, do you know of any lawsuits that are stated? Amazon, Workday?
Not against those big ones yet, but they have come after I think a staffing firm and maybe a company. There's been at least one or two, and they're coming. They're coming. Let's give it down. Sorry. I'll go back to these people. I didn't do it. That's my artificial intelligence. Sorry. DEI, LGBTQ, and civil rights. Again, this should not be a big shocker if you watch any of the political commercials, but the Biden administration and the various agencies have been pushing out lots and lots of legislation and laws, mostly on the pregnancy side and pregnancy discrimination side of things, but they're also, they have been very supportive of the LGBTQ community and making discrimination against that group as illegal as all other protected classifications. So the Biden administration has sort of been a champion of that stuff. What's Trump going to do? Well, I think unless he's not going to make good on any of his campaign promises, which he's really not known for doing, he's certainly going to attack sports. That was a big one. It was a big one statewide too. I would tell you this is a big red herring nonsense issue, but it's an issue to some people. And so to make good on some promises, I think he's probably going to touch this area in some way, or his EEOC is going to limit the scope of their involvement in these cases. The pregnancy laws that have passed, and I mentioned a few of them here from the Biden administration, the Pregnant Worker Fairness Act, the Pumping of Work Act. I look at those laws and they're nice and I understand where they're going, but they're really not groundbreaking in any way. There's already the ADA. There's already pump laws out there where you have to give a reasonable accommodation to allow women to express milk during the workday, private room, not in a room with cameras or a bathroom or something stupid like that, which by the way, I've had that case. So those laws are out there already. These laws are sort of just a continuation on those. So it's not that shocking. It doesn't move the needle that much. I don't know that Trump is going to really touch those laws. But again, watch for state laws, because state laws can be much more restrictive than federal laws. And you have to just be on the lookout for that. Usually state law, if they're not going to do anything new and original, they will glom on to federal law and make it the state law. So you just have to be aware of that. Okay, a couple of additional random predictions for me. And by the way, everyone's taking pictures here. I'd like to think that you're taking pictures of me, but you're not. You're taking pictures of slides. We will make the slide presentation available to you. No questions asked, free of charge.
We're also recording, so we'll get the recording out.
We've got recordings too, so the big laughs I got early on, hopefully the mics got that. So some other predictions. Some touch on a little bit of employment law, some don't. I was at a dinner party or at a dinner the other night, and I'm sitting at a table with a business owner, accountant, some other professionals, and I mentioned the CTA, the Corporate Transparency Act. And my firm is all over this like crazy. Lots of law firms haven't touched this act. A lot of accounting firms won't touch this act. They're afraid of liability. We have we've been doing it for the last year. Unfortunately, much like holiday shopping, people wait to the last minute to take care of these things. And I couldn't believe at this dinner party, I got blank stares when I talked about the Corporate Transparency Act. This is a big deal, especially for small business. If you've got 20 or fewer employees, that's one of the exemptions. I don't pretend to be a CTA lawyer. I got a team of them back at my firm. But the CTA is nasty. You have to file, you can do it yourself. You don't need a lawyer to do it. You don't need an accountant to do it. Biased as I am, I would tell you, you should do it with a lawyer, maybe an accountant, just to make sure you dot your I's, cross your T's. Because if there's more involvement than just filling out a form, you've got to really go deep into the ownership and the structure of the LLC or the company, you should have it done professionally. We've started to flat rate these things for clients, especially clients that have multiple LLCs. So if you think of a company that's got 20 or fewer employees, but they've got 4 or 5 LLCs, one owns the IP, one owns this, one owns that, you've got to register all of those LLCs to show the government who's running them, who owns them, who's the beneficial owner of them. Okay, this has been out there for a year, and I got to tell you, the government's done the world's worst job of telling businesses about this. And if you formed a business in 2024, you only had 90 days to report. And if you have a business that was pre-2020, your date is coming up January 1. And if you don't get it in, there's penalties, there's fines, there's jail time potential. Now, I don't think they're going to pull the jail time deal. OSHA's got jail time ability, DOL's got jail time. It's very, very rare that they pull that out, certainly immediately. Down the road, if you're a really bad actor, maybe. But it's a law. And I don't think Trump's going to reverse it. I think it's coming. What they might do and what I think they should do, just based on how blank the stares are I'm seeing in this room, the CTA, I've never heard of this. I have my house in an LLC. Does that apply to me? It very well could. There's lots of exemptions. So you have to figure out whether you're exempt from this law. If you're not, you've got to file. And you don't have a long time to do it. So that's a big one. I think this is my prediction. I hope I'm right. I hope they kick this date out. I hope they kick the date out because we're getting a flood of this stuff. There's not a lot of law firms out there that are doing it. And at a certain point, we're going to have to say no. We've got too much of it. It's coming in fast and furious right now. Yeah.
A lot of people have registered even if their LLC was under 20 employees because they don't know what's going to happen in the future. And they'll forget about it.
Well, if you're under 20, you have to file. It's the exemption is if you're bigger than 20. Yeah.
I'm sorry, the other way around.
Right. So yeah. So, and again, I don't even try to pretend I'm a CTA lawyer. I had to get educated by my team about this law. So if you don't know what I'm talking about, talk to somebody about it. That is a big one, and I hope my prediction is right. I hope they kick this law out because nobody seems to know about it. Not Joe Friday sitting around with their own little LLCs over here. Not companies that are actually going ventures. If you don't have in-house counsel or lawyers floating stuff to you, that's a big one. Next prediction, non-competes. During the last year, we saw the Federal Trade Commission swing and miss, okay? And every law firm that's out there put out all kinds of hell and high water, oh my God, you've got to get rid of these things, you've got to do X, Y, and Z. I did not do that. We did not do that because I have great faith in the state of Texas. And my faith in the state of Texas came home to roost yet again. It's again, I'll say this in favor of Texas. It's where overreaching laws go to die. And this was an overreach. To go federal with getting rid of non-competes, you can not like non-competes, that's fine, I get it. Lawyers never sign them. We write them. We're ethically prohibited from signing a non-compete, I would tell you in our defense. But in any case, they're tough. Some non-competes are tough. But if you're selling a company, how can you say that I'm going to sell the company and then I'm going to go right down the street and I'm going to compete with the company and I know all the clients, they all love me, but I'm selling this worthless hunk of garbage to these suckers and I'm going to go compete. So there is a place for non-competes. And the FTC, I would argue, overreached, went a little too far, and it got shot down in the courts. There's still an appeal out there, sort of, but it's going to go down. And the Trump administration certainly is not going to enforce a national ban on non-competes. However, remember what I said early on. You don't have to worry about the Fed. You got to worry about the state. Because California has outlawed non-competes for years, maybe even be a decade. And all the other California acolyte states out there, Oregon, Washington, even Minneapolis, even Minnesota, they're starting to get rid of non-competes. Georgia back in the day didn't do non-competes. They flipped. Illinois is going to flip. New York's going to flip. Everyone's flipping. So the states will run this day on non-competes. So you need to be very cognizant, especially if you have multi-state facilities, not doing a one-size-fits-all agreement for everything. Yeah.
Did the non-compete legislation include non-solicitation?
It does not. So they didn't overreach that far. So you can still do non-solicitations, and we do them all the time. One of the first questions I ask any client who wants to do a non-compete is, do you really need one? Because even if they're legal, and they are legal in Ohio, I ask the question, do you really need it? Do you need to stop them from working in their trade? Or do you just need to really stop them from taking your clients away, taking your employees away? The answer is, that's what I need. Don't even think about non-competes. Judges don't like them either. Right? But if you need them, you should be able to do them, I would argue. And on a federal level, that was an overreach. Last one. Some of you might be a little sad about this, and I get it. And it doesn't look good from a global perspective, but the U.S. continues to be the only industrialized society that does not have national paid leave. I don't expect that to change under the Trump administration. Lots of other Democrat administrations have tried, failed, and that's in large part due to the Congress. But look at the states. Once again, state by state by state. Illinois is changing that. California and all those states out there certainly changed it a long time ago. New York, crazy. all those coastal states, by and large, have something in place, and some even have it city by city. Different policies for wage, different policies for leave, city by city, borough by borough, sometimes in New York. So you have to be very careful about that stuff. So those predictions, I think, are going to come home to roost. Think about environmental law. Think about energy law. Think about all the other deregulation that's probably coming our way in the next 4 years. That's a pretty easy prediction too, I think. Just real quick, we'll save questions for the end. I want you to leave with some proactive things that you can do when you leave this room, when you leave virtual land, and go back to your companies to protect against what I think is going to come under Trump administration. But it's just good employment law in general, regardless of who's in office. Some proactive measures to consider. So the preventative measures that I think you should be considering in 2025. Employment applications. Start right at the front door before they even become an employee. They want a job from you. They got to sign your application. And I still to this day find applications written on papyrus, and not literally, but it looks like they're done on a daisy wheel printer, and they're garbage, and they bought them from some out of business office supply company back in the 80s, and they're still asking questions. When did you graduate from high school? What church do you belong to? I mean, silly, stupid stuff that went out of vogue a long time ago. This is not a Biden thing. This is a long time ago thing. Your applications, make sure your applications do what they can do. And you can get on the front end, before employees join in, you can get them to waive statutes of limitations, lower statute of limitations, agree that they're at-will employees up front. If they lie on anything in the application, that is a terminable reason right there. That has nothing to do with any protected classifications. You can put a lot of protective stuff in your applications. And especially if you haven't looked at them in a while, that's something to review with your friendly neighborhood employment lawyer. Handbooks and training. I'm in crazy handbook mode right now. It's the end of the year. The beginning of the year is starting. Handbooks are starting to flood into me. And reviewing handbooks, because look, HR people, wonderful, wonderful, very knowledgeable, smart people. You're all in this room. You don't litigate cases. And so when you write a handbook, I can't say it strongly enough, you can write all the great policy you want, but you have to have the eye towards litigation. And what do your words mean in your handbook? Because you wrote them. If you write them and they sound like you've got a job, or as long as you don't do anything bad, that's a promise of sorts. If you have benefits in there that don't comply, I can't tell you how many handbooks I see that promise the FMLA when the company doesn't have 50 employees. Well, you just bought the FMLA. You might want to buy the FMLA. That's okay. But if you don't know that you're buying it, that's a problem. Okay? So handbooks, reviewing them, and then training on the handbooks. Roll them out, train your supervisors first, train your employees next. You'll hear some things from your supervisors that might make you want to change your handbooks before you give them to your employees. So that's the order I always do them in. Supervisory training along the way on all the discrimination stuff that's in handbooks. That's when I do it. That's when the company should do it. Okay. Non-competes, non-solicitation agreements, we mentioned those before. They're still legal. They're still legal. I think they're still legal in Missouri too for the Kansas City and St. Louis folks on the call. I write them all the time. I also break them all the time. Okay? So this is a joyous area for lawyers where we can play both sides of the fence. And I represent executives sometimes that are breaking their non-competes, and I represent companies trying to enforce them. If they're well written and they're enforceable, and you're in a state that they're enforceable, you're going to court maybe. Okay. Severance agreements. I mentioned this before. Somebody asked the question on the back end. If I came to you, Richard, and I said, "Hey, Rich, you've done a good time with your company. It's named after you, after all, and it's time for you to go out the door." Okay. You're over 40, barely. I don't want an age lawsuit from you. So here's a bag of money, and all you have to do is sign a piece of paper that says you're not going to sue the rest of your partners as you leave. If Rich doesn't take that bag of money, I've got real concerns. He's not entitled to that bag of money. All I'm asking is for you to not sue the company on your way out the door. If you don't take that deal, I view you as a litigant. Save the money. Don't pay the severance. And unfortunately, you're going to have to pay me to defend the case that's probably coming. Okay? So severance agreements. Treating employees with some heart on the way out, helping them transition with outplacement, with coaching, with all kinds of other bells and whistles out the back door, all buys you a whole lot less headaches down the road as HR professionals and business owners. Supervisory training, I've kicked that one to death. Best bang for your buck, no questions asked. Train your supervisors, train your supervisors, train your supervisors. What was the Latin phrase that I gave you early on? Respondeat superior. Supervisors stand in the place of the company. Okay. ADR programs. ADR is going to come back and come back big during the Trump administration. Locking employees into alternative dispute resolution instead of running to court. There's statistics out there that will tell you that companies win far more cases in front of arbitrators than they do in front of court. And it's less costly, it's private, it's got a lot of things going for it. Can you stop class action lawsuits with these kind of things? You can. They got to be worded really, really well. Otherwise, you're going to fight 2 fights before you get to the point that you can arbitrate. Lastly, and I mentioned this earlier, audits. Employment law audits, wage and hour audits, OSHA audits. Again, great bang for your buck, great ROI. I have clients that have me walk through their plant, hour, 2 hours, write a quickie report, and if OSHA came through the doors right after me, we'll save them 6 figures sometimes. Any manufacturing plant. That plant I mentioned before that got hit for $90,000, if I dropped a sandwich on the ground at that place, I'd pick it up and eat it. They found $90,000 and they didn't even visit 1/10 of that facility. Okay. Big dollars saved with OSHA audits. And there's lots of great safety companies who I partner with in this town, and they will do the audit. I will review the report, keep it work product, attorney-client privilege. That's a great strategy too. You can do the same thing with wage and hour. So if this increase of the white collar exemption comes up, you got to know which employees are going to be targeted and potentially could be overtime eligible and make adjustments. That's an audit issue. And then anytime you step into a new company as an HR person and you don't know what came before you, bringing in me or someone like me to review the employment policies, the paperwork, make sure the files are in the right order, all of that stuff saves you time, money, and headaches. Okay, with that, I'm right around the right time, and it's questions and answers time. I don't know, Nick, are we able to take some?
Yeah, by all means, take some questions.
Yes,
I mean,
you
you have
have back?
people virtually too. I might have some questions. Sure. So
You bet.
In regards to immigration.
Yeah.
The new administration has enthusiastically touted that it's going to engage in mass deportation.
Yes.
Any advice to employers if they're visited by ICE or the local police or the National Guard, whether it's from their state or even another state, they say?
I'm a big fan of gates.
I mean, what do you do? You get, I'm thinking of my landscaper for my HOA, and I'm pretty sure
Yeah.
I can tell where his workforce comes
Yeah. Well, you're going to look, President Obama deported a lot of people too. This isn't just a Trump issue. So do I think it's a big Trump issue? Yeah, I think it's a big Trump issue. And I would expect ICE to be very active. So as an employer, if you know you're in violation, get in compliance. If you can't get in compliance, because it's very, very hard to do, you're going to have to make some calculated business decisions as to whether or not you want to change your workforce or not. Hiding your head in the sand and pretending like you don't know, that's not a defense. So get ready. I represent a hotel chain, and one of their hotels got raided by ICE during the Biden administration. It didn't go well. So now bring a Trump ICE administration in and watch the fur fly. There's going to be some bad things going on out there in terms of immigration. And you as the employer, you knew or should have known, and you really should have known in most cases, it's on you. Yeah.
Why won't Congress raise the legal immigration?
Why won't they?
This problem.
Well, it's a hot button and you got to run on it. So, I mean, immigration was a massive piece of every political candidacy that I saw. And if you're on one side or you're on the other side, they tried to pass the border law. And lots of people point to that border law and say, why didn't the Republicans agree to that? Well, read the border law. It wasn't that great a law. it allowed for a whole lot of illegal immigration to still happen. And that's what the Republicans found fault in. And I happen to believe that you've got to take some baby steps and maybe not go for the whole enchilada, excuse the pun, all at once. But you've got to start somewhere. I mean, it's a problem. And both administrations know it's a problem, but they can't seem to agree on how to solve it. So that's going to continue. That's going to continue.
I'm legal guardian of a person and their estate, and they were working for a large U.S. employer. There were some disciplinary meetings. I felt that I, as guardian, should have been invited to protect my part, and I wasn't. I believe there are probably 80 violations. Unfortunately, my board is not able to cooperate as going forward.
Well, and if there aren't 15 employees, the 88 doesn't apply.
Well, there's 100,000.
Oh, there's plenty.
Yeah.
Yeah, look, all you can do is what you can do.
Well, is there a way for maybe education for employers that if they do have someone who might be a long-term employee and then long or hard times, maybe get a incompetency ruling against them? So then you have a guardian involved, and the guardian should be standing in the shoes of that ward and have the protection.
There is no law that says that.
I understand.
So therefore, I would expect that not to change either.
Okay.
I mean, you saw the closest analogy to that is what the Biden administration did with unions by saying, even though this union doesn't represent the employees in this company, an outside third party, a union, a consultant, somebody has the right, and if the employee asks for it, they have the right to accompany and participate in the investigation. But if that person doesn't do that, it doesn't happen. And if there's no allowance in the law, as there is in the OSHA situation, or the NLRB situation, then it's not going to happen. Nick, was there any?
I'm checking to see if there's any questions.
Okay.
Not-
I think
No,
we have one
getting
more.
to those.
Yeah. In the healthcare space, obviously some people have trended towards being very large claimants with the last of the year, very expensive drugs or even mental health employees. At this point, I know that it kind of bridges the ERISA, ADA, kind of both sides of the coin, but I mean, in terms of being an at-will employee, are those employees pretty much untouchable for employers to fire if they are?
Nope.
No.
No.
There's been a lot of cases pop up where people are, feeling like they were wrongfully terminated or targeted because they were a large client.
Let me think. Every day and twice on Sunday. Yeah, because if you do a lousy job, remember my platinum rules of employment law: document. If they're not a good employee, if their performance isn't good, but you drop it on them like an anvil from the sky, and they didn't see it coming, and they're a large medical issue or a disability case or race or national origin, you name the protected classification, if you didn't do a good job communicating their true objective reasons for the termination and document it, hopefully for us defense people, guess what they're going to think? They're going to think it's because of the protected classification, it's because they were using lots and lots of insurance and were ill or disabled or whatever it is, and you're going to get a lawsuit. So the preventative stuff that I talked about at the end, making sure that you're training, making sure you're documenting well all along the way, and you're not surprising employees, because shock and surprise, that's what results in lawsuits more than anything. Any others? Hold on.
Is E-Verify still left up to the states, and do you see that change?
I am many things, but I'm the furthest thing from an immigration lawyer. I do know E-Verify is still out there, and it's used, but I don't think it's federally required, but don't quote me on that. I have really good friends. Yeah, I don't think it's either. So it's state specific.
Yeah, state specific. You don't see it under Trump.
No. Everything that can stay state under the Trump administration is going to stay state, unless he does away with it entirely. But I don't think he's going to do that either.
Have you had any Homeland Security cases?
Homeland Security cases. I've been in buildings for Homeland Security of storm, but I haven't had a direct case against the Homeland Security agency. No. But you can expect that agency to get some more funding too in the Trump administration. They'll be out there. Okay, with that, I appreciate everyone's attention. I'm glad the coffee has not worn off, but it certainly is keeping me jangling. And again, I'm going to stick around for a little bit. If you've got any questions, happy to help. Thank you to everybody virtually.